Every day in the USA, people find themselves in court.
Okay, well, I apologize for that because somebody apparently doesn't have anything better to do than to spam, just spam courts with inappropriate material. But that's fine because we can have that one investigated just like we did the last one. All right, so let's try this again. And to anybody that's watching live stream and thinks that they're gonna do that again, just be aware that the last one that did that we had an investigation done and that person's been located. So you really wanna make sure you're not screwing around with us. Mr. Mercier, I'm going to go on the record in the matter of.
Oh,
Yeah. Commissioner Amish Parikh, 231925. And counsel, your appearance, please.
Good morning, Your Honor. Daniel Mercier, P72620, representing Amish Parikh, who is not present here right now. This is.
Okay, and so the court will make a record that Mr. Mercier had asked to approach and address the time that he could be present today for this court to issue its ruling on the preliminary examination that was conducted in October, on 2 different dates in October. This matter was set for the parties to return at the end of November with briefs to be completed by November 15th. There were a couple of adjournments for the transcripts to be completed. I understand it was through no fault of counsel. And the court's going to note that the Attorney General is not present at this time because this matter is scheduled for today at 11:30 a.m. Mr. Mercier asked to, or I presume was telling the court that he was not available at 11:30 and he had it in his calendar for 8:30. Is that correct, counsel?
I just was informing the court I would never be so bold to tell the court anything. Thank you, Your Honor.
And the court then, as this was off the record, the court then informed Mr. Mercier that this matter was scheduled for 11:30. And counsel, you indicated that you had it in your calendar for 8:30. And then you requested to appear via Zoom. I stated I was going to step off to confirm whether or not the Attorney General was appearing in person or via Zoom, because there was a request by Mr. Payak to appear via Zoom. However, if that was not acceptable, he was going to have somebody else appearing in his place. He sent the email to the court as well as yourself indicating that a different assistant attorney general would be appearing in his place, which tells me that that person's going to be appearing in person. As the court was leaving the bench to go look at it, Mr. Mercier made the comment that to refresh my recollection, because that I made his client come in person because I don't like him. This court made it very clear that that was not what this court ever stated, and that was a mischaracterization of anything that this court has ever stated. Mr. Mercier, I am unsure as to where you came up with that conclusion, but because this is a criminal matter that involved a lot of documentation because of the charges, this court required your client to be present. It's a criminal matter for an in-person preliminary examination. At no point did this court require your client to appear in person because it did or did not like your client.
Your Honor, I wanted to clarify that, and I attempted to while we were off the record, is that I had previously asked if my client could appear by Zoom because he lives out of state at this point, where he did not previously, and the court informed him that You had previously informed my client that, I believe that the arraignment, or maybe in a hearing that I was not at, that all hearings would be in person, and that he acknowledged that all these things would be in person, even prior to making that motion to you. I did not mean to say, did not like him, off the record, I didn't say that, I retracted, I hope I have clarified that, but I was trying to reference back to the fact that you said, did somebody make a motion for Zoom? I was going to say, I actually made that motion for Zoom, and it was denied because of the fact that he was already notified that these would all be in person, even though he's out of state. And so that's what I was trying to refresh with, and I'm sorry if we had a miscommunication, I own my part on that.
Counsel, there's no miscommunication. You clearly stated that you were trying to refresh my recollection, that I made sure your client came in person because I didn't like him. There was never any statement to that effect, nor any communication otherwise, as I stated, and I stated, as you just did, at the arraignment, that these proceedings would be in person.
And I was not at that hearing, I was at the later hearing where I made the motion. I attempted to clarify, and obviously I did a poor choice of words earlier, Your Honor. I hope that my clarification here on the record allows the court to know I did complete deference court. I understand, I meant I did not mean to upset the court.
I don't even know why that comment would have even come out of your mouth, counsel. Quite frankly, I have no idea why that would have even come out of your mouth. That's not a miscommunication. That's not trying to tell this court what I stated at the arraignment or otherwise.
Well, I appreciate the opportunity to clarify, Your Honor.
And to the best of my understanding, the Attorney General is going to be in person. This court scheduled this matter at 11:30 based upon its docket. And so this matter is set for 11:30. I can't hear it before that. I don't have the Attorney General present. And you put it in your calendar for 8:30. I'm not sure why. On December 5th, the email was communicated from Ms. Shelton to both you and Mr. Payak that stated verbatim, after conferring with Judge DiSanto, we have agreed upon Thursday, December 21st, 11:30 a.m. for the exam continuation, with briefs to be due to the court by December 14th. We understand this is a busy time with the holidays and all, but there are literally no other options based upon our dockets and the court's holiday closures. That was the communication on that date. The court received Mr. Payak's brief on December 14th. The court received your brief on December 18th, and then another one on December 20th, which was yesterday. And there wasn't any request to have this matter moved up in time, or that there was a conflict on your schedule or otherwise. And that email was sent at 9:12 a.m. on December 5th. Over 2 weeks ago. And so counsel, it's at 11:30. I can't do it before that. I don't have the Assistant Attorney General present.
Your Honor, I am scheduled, and I apologize about the calendar issue. That email, by the way, cited, I did not respond to. If I saw that email and saw the time, I would have identified the conflict previously and would have been in contact with your court. I also would have informed the other court when they scheduled the third day in Chief Judge LaToya Miller's courtroom for a third day on an adult juvenile bindover case today to start at 10 o'clock. I would have said I was not available. But now I'm in a difficult situation here, Your Honor. I was attempting to approach you off the record to bring it to the court's attention that with this case being adjourned so many times, in this case, the other case also being continuing, that I kind of I'm in a pickle here. I'm looking to the courts for some guidance and direction. I did not mean to upset the court. I understand the situation. I'm kind of in. I will
counsel, at some point you had to have seen the email because you had it on your schedule for today.
I did not process the time, Your Honor.
Counsel, you're telling me two different things.
I will call Chief Judge Miller's when we're off the record, Your Honor, to see if I can move
counsel,
back, okay?
You're telling me multiple things. One, you're telling me that you had it on your calendar for 8:30. The other, you're telling me that you didn't see the email. And now when I called it to your attention that you must have seen the email because you had it in your schedule for 8:30 today. Now you're telling this court that you didn't put together the time difference. I don't know what it is.
In my electronic calendar, Your Honor, I changed the date, not the time of the previous, how I had it in my calendar.
Okay, but you did receive the email.
I did receive the email. I didn't process the time change, Your Honor. I'm not saying different things. I'm saying I look at my electronic calendar on my phone, that I only changed the date, not the time. It's not a date issue, it's a time issue, Your Honor.
I understand that that's what you're saying right now, but you also just a few moments ago stated to this court, as an officer of the court, that you did not respond to the email because you didn't see it. But you did see it because you changed the date in your calendar.
I didn't see the time in the email, Your Honor. That's it. It's a time issue, Your Honor. I'm only was talking about the time.
And so what is this in which court are you in?
I am in the Chief Judge Latoya Cynthia Miller's courtroom. It is a juvenile adult bind-over case.
And that's Third Circuit?
It is Third Circuit. It's on its third day, Your Honor. And I actually was hoping that it would have been over previously. It wasn't. The date that was scheduled for yesterday that it may have been over was canceled by Chief Judge Miller. And now and so today is a go.
So is this the first day or the third day?
This will be the third day of this hearing. For today, yesterday, I believe we also had a hearing on the 18th, and we had a hearing even before that. So this would be the third day. I was going to ask the court if I could appear by Zoom. I could go to the courtroom there and ask Chief Judge Miller if I could step out into the lobby and appear by Zoom.
And what time is that supposed to start, sir, counsel?
10 o'clock, Your Honor.
Off the record, you told this court you had a bench trial that was scheduled from 10 to 4:30.
That is a bench trial. Miss Miller is the one sitting on the bench, Your Honor. It's in front of her.
What?
Miss Miller, it's not a jury, it's in front of her. It's a bench preliminary exam, Your Honor, in front of Judge Latoya Miller.
Okay, that's not a bench trial, counsel.
Very good, Your Honor. Thank you for that clarification. It's in front of the bench. I was speaking quickly off the record, Your Honor, trying to explain my situation with the time.
Counsel,
What do you want?
you're a seasoned practicing attorney. You know the difference between a preliminary exam, a bench trial, and you told this court off the record you had a bench trial scheduled. There is a difference between a bench trial and a preliminary exam.
I feel we're splitting hairs, Your Honor.
We're not splitting hairs. I want to make sure that I am not being misled. That is what I want to make sure of, counsel.
You are not.
Because at this point, I have some concerns. So we're going to go off the record for a moment.
Misled, Your Honor.
We're going off the record. All right, good morning, Wayne County Jail. Who do we have there?
Good morning to the court.
Good morning. And your name, or I'm sorry, Deputy, who do we have there?
You have Daniel, how do you say that? Brisbois. Daniel Brisbois.
Okay.
And Ronald Prost, or Prost.
Okay, thank you very much. Is Corey here today, or is there only?
Just Neil.
So is he covering those then?
Yes, just Neil.
Okay, Mr. DeBloy, I'm going to put you in a breakout room at the jail. It'll be breakout room 2. Mr. Freer, I have you checked in. Mr. Scanlon. Good morning.
Good morning,
Which
Your
man
Honor.
are you here on?
I'm here on Jonathan Harrison. He's with me in my office. It's a PCC.
Okay, so did you file an appearance on this matter? I showed Mr. Magidson. Are you appearing on his behalf?
No, I filed an appearance in Southgate
When did you file that appearance?
a while ago. We actually faxed it to the court.
Okay, counsel, all right, let me just confirm, I have the 27th district court, or the 28th district court clerk here, so just give me a couple moments.
Right? Feeling the power.
You,
Could not locate Mr. Du Bois.
okay, that's fine. That's fine. Ms. Johnson? Okay, so we are going to go back on the record in the matter of Amish Parikh, 231925. And counsel, your appearance, please.
Attorney Daniel Mercer, P 72620, representing the defendant, is not present.
Okay, so I need to, counsel, I need to speak up because we're having a hard time getting on the recording.
Attorney Daniel Mercer, P 72620, representing Amish Parikh, who is not present.
Okay. Bobby, can you let Angela know that Mr. Bureau's on, so if she can contact his attorney, please? Okay, so counsel, here's what I did. I contacted, Judge Miller, right?
Yes, Your Honor.
Okay, I just don't want to just call her by her first name. I contacted Judge Miller's court and spoke to Judge Miller. And by the way, she's not the chief judge, she's the presiding judge of juvenile. The chief judge of the Third Circuit Court is Judge Prezard. And so apparently this matter, the matter down at Third Circuit at the juvenile at Lincoln Hall of Justice was scheduled for December 18th, 20th, and 21st. Yesterday's was not held due to a situation, an emergency situation that arose. And so it's my understanding that there's about an hour left or so of the proceedings, which is a preliminary examination. Then got in touch with the Assistant Attorney General, who is driving down from Lansing because it's in person. And so she is able, her afternoon is a bit open, so we are going to set this for 1 o'clock. Had you communicated with us prior to this, I wouldn't have spent 2 hours of my docket addressing this situation. I understand calendaring and docketing things happen. I was in private practice for a long while. I understand how that happens. But when you're receiving communication from the court on dates that have been adjourned multiple times, clearly it's in everybody's best interest to look at the entire email to confirm the time. Because it's my understanding this matter was originally scheduled at 8:30 downtown or at Lincoln Hall of Justice, and you had asked to move it. So had you just stuck with that originally, you would have been here for the 11:30 to begin with. I'll see you back at 1 o'clock.
I apologize.
Let's go off the record. Okay, I apologize to everybody for the delay that we've had today. So, Mr. Collins, good morning.
Good morning to you, Judge.
All right, I appreciate you logging in for the spot appointment. And so I'm going to move you and your client into breakout room 5.
Thank you, Judge.
Okay. Okay, and we are on the record in the matter of the state of Michigan versus Desmond Jennings, 232395. Where's Mr. Du Bois?
Can you send in Mr. Du Bois? Mr. who? Mr. Du Bois.
Neil, please. Okay, actually, while we're waiting for that, we're on the record in the matter of 28 District Court case number 170576. State of Michigan versus Katrina Burns.
Good morning, Your Honor. Jeffrey Glazer, P46892 on behalf of Ms. Burns. She's in the waiting room. If you could bring her back in, Judge, please.
Oh, she was, okay. She wasn't here. Oh, there she is. Okay. Okay, Ms. Burns, can you please unmute and turn your camera on?
Hi, Your Honor.
Okay. Ma'am, you're in court, so I need you to be dressed a bit more appropriately. Do you have a t-shirt on or something?
Oh, I do. Okay. I put on a jacket. Hold on one second.
Okay, and I need you to go into a quiet room, please.
Okay.
And counsel, I'll have your client place her name on the record in just a moment.
Yes, Judge.
Today's scheduled for probable cause conference.
Yes, Judge. I just got appointed Tuesday, excuse me. It's a 2017 case. I did make a demand for discovery. They're going to get that to me, Judge. However, they don't have it today. So I'm asking to adjourn the PCC to the next available date.
So you said you were appointed on what date?
Tuesday.
Okay, we will adjourn this matter, this PCC to January 5th. Does that work, counsel?
It does, Judge.
Okay, and Ms. Burns, can you please state your name for the record?
Natrina Burns.
Okay, and ma'am, or counsel, you gone over your client's rights and waive your client's waiving time?
Yes, Judge. I had a chance to talk to Ms. Burns. I advised her she has a right to have an examination within 21 days from the date she was arraigned. In order for me to get all the discovery and possible digital discovery, we're going to go beyond that date. And she understands she's waiving that. Is that correct, Ms. Burns? You got
Yes, sir. Yes, sir.
Okay, all right, and ma'am, I do apologize for the delay today. There was an unexpected delay, quite unnecessary as well. So I do apologize for that. The court's going to adjourn this matter to January 5th at 9 a.m. Time having been waived for the record, bonding conditions are continued. Anything else, counsel?
No, Judge. Have a great weekend. Have a great holiday.
Thank you, you as well. Okay. All right.